My name is Tim Moore, and I serve as the Deputy Director at the Center for the Study of the American Constitution at the University of Wisconsin in Madison. Well, we're joined today by John Kaminsky. He is the Director of the Center for the Study of the American Constitution. He also is the Editor-in-Chief of the Documentary History of the Ratification of the American Constitution, a 30-plus volume set of primary source materials related to the ratification of the Constitution. We just completed that set and are starting on a new documentary project, creation and ratification of the Bill of Rights. So, John, thanks for joining us today. This particular conference, A Necessary Evil, it kind of is an interesting, I'll give you a brief background. As many of the events unfolded this year, and various politicians weighing in on the issues of race. I think John and I both looked at all the events, and as well as some comments made by specific politicians about the necessity of slavery to the creation of the Union. So John and I have been talking about putting this together, and it just so happens that John put together a documentary book back a while ago called A Necessary Evil. So much of our Q&A here the next 30, 40 minutes will roughly be approximating the sequence that John laid out in his book. We'll kind of helicopter in occasionally, and some of the questions relate directly to specific documents in John's book. So that might be of assistance as we track through. So John, thanks for being with us. And I'd like to start out early. And I think the first question I might have is, before the Revolutionary War, were there attempts by American colonials to address the issue of slavery, or indeed get rid of slavery?
There was never a real systematic, organized effort to eliminate slavery. There was never a systematic effort to enslave Blacks. It was sort of an ad hoc thing that developed. 1619, the first Blacks were brought in from the Dutch, and their status was uncertain. But gradually, it developed into a chattel slavery system. Each colony had its own rules, regulations, laws dealing with slavery. There was no organized system, no federal system. It was quite disorganized. And the attempts to eliminate slavery followed that same decentralized pattern. And so different religions at different times would advocate for an amelioration of the condition of slaves, all the way to the emancipation of slaves. I'd say virtually everyone had a denunciation of the slave trade. And so that was an easy thing to denounce because of the inhumanity of that, both inhumanity from the point of view of taking free men, women, and children from their homeland and forcibly bringing them to America, to the West Indies first, to the South next, and then to northern states as well. But also the tremendously cruel and inhumane conditions in that African slave trade. So that was pretty easy to denounce. And some groups did, particularly the Quakers took the lead. Anthony Benezet was the obvious leader in that movement from Philadelphia, but never gained really much headway at all. But when the revolutionary movement did start taking place, you got more obvious disconnect between the rhetoric of slavery and tyranny exercised by Great Britain over American colonists And then the fact that the colonists themselves were holding a race of people in slavery. And so you get the idea that freedom should take place, emancipation should take place. And that is pretty well typified by a certain individual in Georgia, let's say, Lackland McIntosh, whose father was against slavery. Slavery was not allowed in Georgia at first, during the first 25 years of its existence, when it was a special colony for debtors and prisoners. But there was no slavery there. At the end of that 25-year period, when Georgia became a royal colony, they had to make the choice: would they be a slave, would they allow slavery or not? And they decided they needed slavery to be competitive with South Carolina, its neighbor. And so they started slavery. They institutionalized slavery. And Lackland McIntosh's father, although an opponent of slavery, once that decision was made for the colony, he went out and bought slaves. And so when Lackland McIntosh inherited these slaves from his father, he was a typical slave owner, I would say. Didn't bother him that much to own slaves. But when the revolution came along in 1774, 1775, no declaration yet of independence, McIntosh saw the disconnect there, and he circulated petitions calling for the emancipation of slaves. And this was to be done immediately, no hesitation. And so he got the message that there was a disagreement between what they were saying, protecting themselves, Americans, and what they were actually doing. And so he circulated these petitions advocating the immediate emancipation of slaves. Well, that didn't happen. But about 10 years later or so, 15 years later, when the Constitution was being considered, McIntosh had a complete different point of view. He saw that the Constitution would allow Congress to prohibit the slave trade, foreign slave trade, in 1808. And that bothered him because he now said, we need slaves. And so he had done a complete 180 shift. He had gone from being an abolitionist in 1774, 75 to being a staunch advocate of slavery and, in fact, an advocate of the slave trade. And so the country sort of mirrored Lackland McIntosh. And so there was this fervor around the time of the revolution to eliminate slavery, but it didn't persist after the war.
Maybe this is a simple yes/no answer, but many people, I think, there's this discernible difference between northern colonies and southern colonies in relationship to slavery. Is that not the case then, that there's a distinction of how northern colonies versus southern colonies approach the issue? I mean, you mentioned Georgia there, so that distinction not really there?
The simple answer to that is yes and no. Not so simple.
Somehow I knew that was a possibility.
The simple answer is yes, there's a difference. Every state, every colony had slaves. So all 13 of the colonies had slaves. The question is, how many slaves did you have? What proportion of your population, what measure of your economy was based upon slavery? And so that's where there's a difference. The northern states rely less upon slavery than the southern colonies do. This is true throughout American history, whether it's colonial or post-revolution. Now, if you look at New York after the Revolution, it had about the same number of slaves as Georgia had. And so the, the New York population was a little bit larger, not a lot larger, but it had the same number of slaves. New York was not considered a big state at that time. And so you're talking about the percentage of population and the importance to the economy. On the other side, so there was a difference, North versus South. The other side of the issue that I mentioned, where there is no difference, is the perspective of racism. Racism is rampant throughout Western civilization, Europe and America. There's a profound racism in the world, and that persists in America. And so when you find that slaves are emancipated, that doesn't stop the problem for freedmen. They still face problems. And in the North, when you get more and more emancipation, you see that the attitude toward racism is increased. And so it's an anomaly here. You get rid of slavery because of the inhumanity of it, but at the same time, you increase racism, particularly in the North. It's not to say you decrease racism in the South, no, but you the institution of slavery sort of puts racism on the back burner. You accept the fact that there is a difference in the races by allowing you to enslave all these people. You don't have to come out and openly advocate your racism. It's just there. Whereas in the North, the racism does come through loud and clear after you get a sizable number of freedmen in their state.
Some have suggested that Lord Dunmore's proclamation and the Somerset case figured heavily on the minds of Americans and moved them to revolution to protect slavery because of those two events. How would you address those questions?
I don't think that they had much effect on the coming of the revolution. Certainly, there was fear on the part of Americans opposing Dunmore's proclamation, which was in November of 1775. What Dunmore advocated was that slaves should run away and join the British forces. And once they did that, once they joined the British forces, they'd be granted their emancipation. The Americans denounced this as inciting a form of domestic insurrection. And in fact, that's the euphemistic word, phrase that's used in the Declaration of Independence. Jefferson doesn't refer to Lord Dunmore or his proclamation. He says they have incited domestic insurrection. And that's what they saw. Americans, particularly in the South, had a deep, deep fear of slave rebellions. And that could be on a large scale. It could be on an individual basis, where a slave might poison the master if the slave had access to the kitchen, let's say. So there was a real fear that slave owners and their families felt toward any kind of slave uprising. And Dunmore obviously contributed to that. So there's a real hatred on the part of Americans for what Dunmore did. Make no mistake, Dunmore did not make his proclamation out of any moral or humanitarian perspective. He owned slaves himself, and he didn't free his slaves. This was done for a political military reason on the part of Dunmore. The Somerset case was perhaps a different perspective Americans had of that case, in that there was not necessarily an animosity against Lord Mansfield, who was the judge in this case, but it did raise somewhat of a specter in that that case, which was decided in 1772, it was decided that a slave uh, uh, owned by a master who had purchased that slave in the New World, brought him to England. This is James Somerset, the slave, and wanted to take him out. He had escaped, had been recaptured, and the owner wanted to take him to the New World and sell him. He couldn't sell him in England. And so that was what the case was about. Could the master take Somerset out of England to sell him? And what Lord Dunmore, what Lord Mansfield ruled was that that was not acceptable. There was nothing in the English common law and nothing in the statutory law that would allow such a thing to take place. And so it was a very specific judgment in this one case. But the media and people looking at it had a broader perspective, in essence saying that slavery was not allowed in England. Well, there were still slaves that were in England even after the Somerset case. But it did raise somewhat of a specter in America that the England could interfere with the institution of slavery in America. It didn't. It didn't interfere with slavery in English colonies, not just the mainland colonies, but the West Indies colonies. It was too profitable. Slavery was too profitable for that to get much support in England. There's always an anti-slavery segment in England, but they got little headway at this time. And so I don't believe that the Dunmore's proclamation or Lord Howe's proclamation that occurred, known as the Philipsburg Declaration in 1775, which provided for the emancipation of any slave that came over to the British, didn't have to fight. Lord Dunmore, you had to join the military to get your freedom. But Lord Howe's proclamation, you didn't have to fight. Those were just viewed as hated actions to unsettle the situation in the South and presented a danger, whereas Somerset was a more general kind of case. And I don't think either one contributed toward emancipation per se. And about 80 to 100,000 slaves ran away during the American Revolution. When the British left America, the final evacuation in 1783, about 3,000 slaves were recorded as being taken away. Most of them went to Nova Scotia. And so the British had a policy of trying to harm the American institution of slavery. And it was readily shown in the proclamations of Dunmore and Howe. But it only angered Americans and did not really help in the long run to get rid of slavery.
I was looking through a portion of your book, and I was struck by so many revolutionary period statements of bills of rights, and there's so much rhetoric and language of freedom and liberty, and I think to the casual observer, you would look at that and you say, well, how in the heck could you make these statements and all these formalized documents and yet still enslave? But I think, and I've heard you mention this before, that there's a slight caveat in many of those declarations of freedoms and liberties. Maybe you could address that a little bit, that there is an out clause, an exception when it comes to slaves.
Yes, well, that's particularly well shown in the Virginia Declaration of Rights. Uh, it has the clause very much like the Declaration of Independence that starts out, all men are created equal. Now, how do you justify such a clause when you're holding a whole race of people in bondage? And the way they got around that in the Virginia Declaration of Rights was they added a phrase, when they enter into society. All men, when they enter into into society, are born equal. Uh, uh, that's not uh, going to apply to blacks. Blacks never enter into society with Americans, with white Americans. And so it's very easy to segregate them out from that rhetoric of all men are created equal. And in fact, that's the very principle that Chief Justice Taney uses in writing the opinion on Dred Scott in 1857, that Dred Scott had no standing to sue in a federal court because he was not part of American society. Blacks were not part of American society, and so that's the um, the caveat that's there for most Americans to follow. And in fact, you'll find that's the case on an individual basis also. Jefferson, on many occasions, denounced the institution of slavery as a moral evil. And he said, I, more than anybody else, wants to get rid of slavery. But he always says it has to be done in a certain way. It has to be done to avoid ill consequences. There was always a way out for him to excuse himself from emancipating his slaves. And so this is a real quandary that American slaveholders have at this time. I think most of them, if they really looked in their hearts, would say slavery was wrong, but they justified their continued use of slaves on the basis of, first of all, they needed them financially. There was a real benefit that they derived, and second of all, there was some justification for this, that the alternative was worse than the institution of slavery. And obviously, when they're talking about the consequences being ill, it didn't bear directly on the part of the slaves. That consequence was right there and present, but it was for the country, the colony or the state, or the American people, the white people. The consequences for them would be disastrous if there was immediate emancipation of all the slaves. So that was not possible. And it became true also for an individual, that this is the way that an individual might hold on to their slaves, saying, well, if we could just find a way to do this, we should do it. But they never seem to be able to find a way to do it.
I'd like to fast forward into the convention, Constitutional Convention, Philadelphia, uh, and it's often stated, and I'd like to do a little maybe some hypothetical speculation at this point, John. It's often said that the South kind of threatened Union if they didn't get protections of slavery. Um, do you, in your assessment, do you think that threat was valid? That they could hold the Union hostage with this threat in the convention?
But this is particularly true of South Carolina and Georgia. But the delegates from those two states also lump in North Carolina as partaking in this attitude. And they say two things. One, they'll walk out of the convention, and two, their people wouldn't ratify the Constitution. And so the whole convention realized that to obtain ratification, you needed a certain number of states. Under the Articles, you needed unanimity. They knew that was not possible. And so eventually they understood they had to come up with a number. And eventually they chose 9 states. 9 was a number that they were familiar with in the Articles of Confederation because it took 9 states to adopt important legislation, declaring war, borrowing money, uh, um, assessing certain taxes, let's say, allowing new states to enter. All these things took 9 states to ratify it, so to adopt in the Confederation Congress. And so that's a number they adopted. They felt they could get a majority of people with 9 states ratifying. If 7 small states ratified, they felt they would perhaps not have a majority of the people. But with 9 states, they can get a majority of the people and a majority, obviously, a large majority of the states, 9 out of 13. So they're searching from the very beginning as to what number would be used to obtain ratification. And so they can count backwards. They knew that Rhode Island would not ratify. Rhode Island was not there. And there was a good chance that New York would not ratify. So now they're down to 11 possibilities. And if Virginia didn't ratify, then in all likelihood, North Carolina would not ratify as well. Now you're down to 9. And so they're very aware of this. And they know if they lose Georgia and South Carolina and maybe North Carolina, you're not going to get ratification. And so from that perspective, I think there was a considerable fear on the part of many of the delegates that this threat from Georgia and South Carolina and maybe North Carolina was an ominous threat. But by the same token, everyone realized how dependent Georgia and South Carolina were on the Union. In 1782, as the war was winding down, the British still controlled much of Georgia and South Carolina. They'd captured Savannah and they'd captured Charleston. And there were peace feelers that were out to end the war. And one method of stopping the war was to say, you go back to the condition of 1763. That is, the American colonies would still be colonies, but they'd be under the British. And we have the conditions existing as of 1763. That is before the Stamp Act. That was unacceptable to Americans. Another possible condition for the peace was, let's have it the way we're situated right now in 1782, which would have meant that Georgia and South Carolina would remain with the British because they were occupied by the British. Well, the Georgians and the South Carolinians were up in arms over that. They did not want to go back to Great Britain. They wanted to be in the Union. And so for them to threaten in 1787 that they would separate from the Union was disingenuous. No one really expected that Georgia and South Carolina, particularly Georgia, could make it on its own. It needed to be part of the Union. But still there was that fear that they would contribute to the demise of the Constitution. They wouldn't leave the Union. It's just that the Union wouldn't have the Constitution and they'd still remain under the Articles of Confederation. And so from that perspective, it was a viable fear on the part of the other delegates.
Since we're on numbers, maybe you could briefly explain the origins and evolution of the 3/5 clause.
When the Articles of Confederation were being debated in Congress in 1776 and 1777, they had to decide how delegates would be apportioned among the states. And and also they had to decide how taxes were to be apportioned among the states. But they decided the representation would be equal. All the states would have one vote in Congress. They could have between 2 and 7 delegates to have a complete delegation, but they only got one vote. And so the large states didn't like it, but they understood that the small states would not agree to any other kind of proportional representation, where the large states, and I should mention that there were only 3 large states at this time. That's Virginia is the largest state, which at that time, in 1777, let's say, Virginia consisted of present-day Virginia, West Virginia, Kentucky, Ohio, Indiana, Illinois, Michigan, Wisconsin, and part of Minnesota. So Virginia was quite big. Since there were only 3 large states, the small states held sway here, and they kept this equality of the states as far as representation. So the issue became also on taxation. How would that be assessed? And it was decided by, it was recommended by population. If that was the case, how do you count slaves? It was eventually decided they could not agree. And so it was decided to apportion slaves on apportion taxes on the basis of land values. And so that's what's in the Articles of Confederation. By 1783, it was evident that that was not a viable system. States were not submitting their land valuations. And if they did submit their land valuations, they underestimated the value of their land. Very much like today, if you own a house, you'd like for your house to be assessed at a lower rate so that your taxes will be lower. Once you want to sell your house, however, you would like that assessment to go up so you get the biggest price, the largest price for your house. And so they decided in 1783 that they needed to change the system of apportioning taxes throughout the country. And so they proposed an amendment to the Articles of Confederation that would base taxes on the basis of population. Then the question again rears its ugly head. What about slavery? How do you count the slaves? And so you get various recommendations. The South advocates that slaves should not be considered because they were not people, they were property. The Northerners, their position was that slaves were in fact people and therefore should be included in that apportioning of taxes based upon population. And so various alternatives were suggested here, from the 100% of slaves being or not being counted. And so some said 75% of the slaves should be counted. Some said 50% of the slaves should be counted. It was James Madison who proposed 60%, which was 3/5 of the slaves should be counted. And that was what was adopted in 1783, proposed, I should say, an amendment. 11 of the 13 states agreed to that amendment. Only Rhode Island and New Hampshire do not agree. But that amendment goes into effect because Congress had no alternative as far as making requisitions on the states for federal expenses, taxes, let's say. And so that's the system that is proposed. That ratio was called the federal ratio. Now, fast forward to the Constitutional Convention in 1787, the issue becomes representation, not taxation. And so the Virginia plan that initiates the debate in the Constitutional Convention on the 29th of May, 1787, calls for the establishment of a bicameral Congress as opposed to the unicameral Confederation Congress, and that both houses should be proportioned among the states on the basis of free white population. It's an interesting point of view to come from Virginia, which owns so many slaves, but that was the Virginia plan based upon free white population. In the course of the debate over the representation in Congress, the small states severely object to proportional representation. In fact, one of the few instructions given to delegates to the Constitutional Convention, Delaware, provides that their delegates should not give up the equal representation that exists in the Confederation Congress. And so they debate this issue, and eventually it was decided with a great compromise advocated by a number of delegates, John Dickinson of Delaware and two of the delegates from Connecticut. So it's occasionally referred to as the Connecticut Compromise, that there should be the two houses, that the upper house, the one house would be equally apportioned among the states, and the other house would be proportioned as far as population goes. That house, the House of Representatives, would also include 3/5 of the slaves. It was decided to go with that number. They were familiar with that number. It seemed to work. It satisfied Northerners and Southerners. Neither side was happy with it, but they were satisfied. It was a true compromise. Each section of the country believed they gave up something. The Southerners wanted 100% representation. It's interesting to note that the benchmark that they were coming from changed. Whereas in 1783, they were talking about taxes. The Southerners were saying that slaves were not people at that time, and thus should not be considered in apportioning taxes. And the Northerners believed slaves were people and should be considered for tax purposes. That shifts now in 87, so that now the issue is not the stick of taxes, but the carrot of representation. And so the Southerners now say that slaves are in fact people and should be represented in Congress, whereas the Northerners say no, slaves are not people, they are property and should not be represented in Congress. Now, when I say represented, I don't mean that the slaves themselves would have representation. It's just the number of slaves would be given to those states. And that's also an important point that is not recognized today too much. The 3/5 clause does not apply to a person. It doesn't say a Black person is 3/5 of a person. It says the total number of slaves in a state should be counted for purposes of representation. And it was added also for purposes of assessing direct taxes. So you have both sides, taxes and representation, being considered in the 3/5 clause. But it applies to the total number, not to an individual. And so you'll see often this statement made that a slave at that time felt he or she was only 3/5 of a person. That is not what the 3/5 clause refers to. It refers to the total number of slaves in a state. The other part of the compromise provided that money bills, revenue bills, would be initiated only in the House of Representatives. And so that house would have more authority. That house that was based upon proportional representation, including 3/5 of the slave population, would decide on what should go in the money bill to begin with.
I think this might be a nice stopping point for our first segment. So thank you, John, and we'll reconvene here in another session.